Take a look at this XRP lawsuit. At risk, last attack against crypto may lead to more lawsuits. Recently, Ron Hammond, who is the director of government relations at the Blockchain Association, expressed his opinions regarding the future of the Securities and Exchange Commission under the leadership of Gary Gensler. This was particularly significant in light of the political pressure that Gensler is facing and the possibility of changes occurring in the course of the next few months. When Hammond was asked about the prospect of SEC Chairman Gary Gensler increasing the number of enforcement actions before he leaves office, he responded by saying that such a situation is entirely feasible. This inquiry was made during an interview with Thinking Crypto. The acts of the Securities and Exchange Commission, SEC, have been impacted by political influences in the past, particularly when the commission unexpectedly approved a Bitcoin exchange-traded fund. Furthermore, Hammond noted that political factors might continue to influence Gensler's decisions, and that Gensler might file other cases or take other aggressive moves prior to stepping down from his position. There is a possibility that the Securities and Exchange Commission will make other last-minute actions in the months to come, given the contentious character of Gensler's tenure. Additionally, Hammond made reference to a number of enforcement actions taken by the Securities and Exchange Commission, specifically the case about Coinbase, in which the SEC issued a Wells notice only a few hours before Coinbase was scheduled to testify before a House committee. According to his argument, this indicated that the steps taken by the SEC might have been carefully timed in order to disturb the continuing conversations regarding the structure of the cryptocurrency market. Regarding the future, Hammond voiced his hope that Gensler would depart before the end of the year, which would result in significant changes to the position that the SEC takes regarding cryptocurrencies. On the other hand, he cautioned that even if Gensler were to resign, the cryptocurrency business would still be confronted with difficulties, and it is questionable whether the incoming leadership would be more crypto-friendly. There is still a lack of clarity regarding the future of Bitcoin regulation. The next phase of cryptocurrency regulation will be significantly dependent on who is in charge of the Securities and Exchange Commission, according to Hammond. A lot of things are still up in the air, but the leadership shift could be the deciding factor in whether or not the SC adopts policies that are more crypto-friendly. Recent strategic moves by Ripple include the announcement of key exchange listings and the buyback of XRP. The large repurchase that Ripple has announced is widely seen by analysts as a crucial component of the deal with the SEC, which gives their predictions more weight. The fact that more than 90 central banks are considering adding XRP to their coin portfolios and expanding the XRP ledger increases the cryptocurrency's potential effect. According to the most recent reports, Ripple Labs and the SEC have decided to put more emphasis on what happened prior to the SEC's lawsuit. Ripple has shown its eagerness to comply with the regulatory body by accepting the Securities and Exchange Commission's discovery request for remedies. However, Ripple retains the right to challenge any findings that are made subsequent to the filing of the complaint. Anthony M. Barrico, a key witness, will be available to take a deposition by the Securities and Exchange Commission, KEL, during the next 3 months. The proposed administrative plan included a set of due dates for the outstanding charge connected with selling XRP to institutional investors. Even while Thursday's session went well, there was still no indication that a resolution was imminent. The overall value of all cryptocurrency in circulation increased by 3.8 on November 9th, reaching $1368 billion USD. The fact that the XRP litigation has not progressed toward a conclusion may have had an effect on Billy and this rise. At the 2023 DC FinTech Week, Brad Garlinghouse, CEO of Ripple, delivered a speech. That is something that might happen, in my opinion. We have publicly recognized this. We will persevere until victory is achieved. Also, Ripple's CEO has said that the Supreme Court is a possible destination and that the company has a good chance of winning there. Well, that's great news. The chances that Vegas would provide us regarding the present Supreme Court would certainly pique our interest. The relevant authorities have not received any cooperation from them regarding the current state of American regulation. Garlinghouse says the following: in politics, it becomes a liability. The speaker made the point that the United States is seen as being behind other countries because of the way the Securities and Exchange Commission dealt with this issue here. How did we get to this point? A few years back, Ripple and the SEC started fighting. Keep in mind, though, that this case has had its share of ups and downs. Occasionally, it seems like one side is in control, but then the other side takes control again. The commission claims that the Securities and Exchange Commission already filed an interlocutory appeal on the XRP verdict, which has only served to amplify the criticism leveled at its price. Since more and more financial institutions are actively using both the native XRP token and other coins that function within the XRP ecosystem, the deadline for Ripple to respond was September 1st, and the CC was required to respond by September 8th. In order to address any further responses that Ripple might make, estimates for this response have reached $10,000. The potential rise in XRP value is indicated by the extent of institutional investment, but this is only the start. According to numerous experts and observers, the current success of the XRP market is mostly due to the seed upcoming resolution of the Ripple dispute. Recent events include the WCC extending a settlement offer to Ripple Labs, a first for the organization. In order to resolve the protracted legal dispute, James consented to pay a large $770 discouragement penalty that the regulatory agency said it might be open to negotiate a better deal for Ripple is significant, despite the fact that Ripple initially turned down a similar offer from this set. In view of the judges and Loris's decision in Ripple's case, this is a huge win for Ripple Labs. Notably, this change aligns with the Federal Reserve and other prominent financial institutions beginning to purchase XRP. Notably, in accordance with the XR plan listing, BlackRock and JP Morgan have jointly acquired more than 7.5 million XRP. The judge ruled that given the potentially large sums of money, it could enable, ledger, and mint were appropriate. Rather than being a security, it is an asset for retail use. This legal clarity has led many experts and analysts to rationally anticipate that XRP would reach $10,000 per coin. Although there may be some who doubt the validity of particular expert opinions, this is far from being an outlier viewpoint. It is reasonable and necessary to value XRP at $10,000 per unit, according to my research, because of its capacity to handle over $120 quadrillion in transactions, its limited supply, and a significant demand for handling such important financial transactions. Institutional XRP transactions totaling $770 are being pursued by the Securities and Exchange Commission, while Ripple is attempting to drastically lower the penalty. What this means is that the amount the blockchain company will have to pay will depend on the outcome of the settlement talks and the court's final decision. An attorney named Johnny Deaton has asserted in the past that in 99.9% of his cases, Ripple would come out on top and that the company would settle for $20 million or less. At the same time, attorney Jeremy Hogan made it plain that instead of using the gross amount, the figure should be expressed as total net earnings from sales. For Ripple, it's a partial win. As per mission, Ripple finally prevailed in its nearly 2-year legal battle with the Securities and Exchange Commission. While selling its CXRP cryptocurrency on public exchanges, Ripple was determined not to have breached federal securities laws. Our decision, District Judge Analisa Torres, was handed down on July 13, and the news simultaneously set off a chain reaction of beneficial outcomes. Then Ripple reacted by saying the SEC failed to give enough notice and that XRP is not a securities. Its reaction was to ask the court to convene a special hearing on the matter. In June of 2021, the court extended the time for the Securities and Exchange Commission to reveal its policy regarding cryptocurrency trading with other entities.